Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Hi, I'm Sharnithia Mitchell.
Thank you. And, sir?
Good morning, Tyrone Fleeman on behalf of the defendant. And this is something that's a little unusual about this lease. This lease is a term lease versus a month-to-month lease or anything like that. And when I say a term, I mean a fixed term, in that the way they build their whole model is that everybody moves in at the same time and everybody moves out at the same time. So they have this mass move in and then this mass move out that is typically tied to the school calendar, right? It's built around I call it the dormitory business model. It's not really a dorm, but they're doing the same thing. And so what happened in this case is Ms. Mitchell showed up and applied for an apartment on, I think, the 28th of August, which was just the day that everybody was moving in at the mass move-in. So she applied way later. Most of the tenants in these buildings, all three of them, apply either when they move out the year before or sometime during the summer. In Ms. Mitchell's case, I don't know for what reason, she just happened to show up at the very last second and applied on that date. She also was of the belief that she had executed a self-guarantee addendum. That would be Exhibit B to the motion. And that addendum calls for a payment of $1,005. Be that as it may, I've submitted an affidavit of Isaiah, who is also here today, indicating that despite his best efforts, he could not find any evidence that that $1,005 was ever paid. So if there's some credit that's due, there's credit that's due, I'll get it straightened out, right? So I was looking for some evidence or a check or whatever, but have never to this day received anything. So I don't believe that $1,005 was ever paid.
You had me scared there for a minute.
I did my best. It's just the number of exhibits that I have to use to kind of show it. And part of the problem that I have in this case is that we're trying to pull information from quite a while ago, and management people have changed, and so I'm recreating a lot out of a bunch of exhibits, but it all does kind of spell out. Next, she goes on to argue for credit of an $82 Michigan Energy draft that she alleges was collected by the Landings. Again, referring to the affidavit of Isaiah, I don't see, he cannot find, rather, any evidence that that $82 was ever applied or that it was ever actually received. Exhibit C and C1 and C2 are what I'm talking about relative to the move out checklist, basically showing that she owed $450.61. Well, the first two items on there are those final electric bills that I'm talking about. And then there's also two gas bills for $44.65 and $24.43, and then $56.36 worth of rent. That's all on Exhibit C1. And so because those amounts weren't paid, because she moved out owing some amount for utilities and some amount for rent, I don't think she has standing to make any of the claims that she is making today.
This energy draft, is this like a tax credit or what? I'm not familiar. There are a couple of varieties. I'm not familiar with all of them.
It was sent to me from the state of Michigan, and it was supposed to be towards any energy draft bill all the way up until December 31st of, I believe, 2022. And also the money orders, I tried to get those tracked down, but I don't know, for some reason I haven't been able to hear back from the Western Union, and I don't know how else to contact them. But there's still $500 that is missing. Look, okay, if it's okay with you guys, I have someone that I would like to represent me.
No,
And no,
unless is this person an attorney?
okay, well, I don't know what else
The rules of
guys-
court are specific that to represent someone else in court, you must be an attorney.
I was pregnant during this whole time, so I could not, like, I wasn't worried about, the money, and I didn't even know that I was missing money until after my pregnancy. Like, the lease is an agreement, a binding agreement, right? So the lease says that I'm supposed to pay $1,005 upon move-in, but I paid $1,340. I understand that it was put towards other places, but like from the beginning, the lease was just, it wasn't honored on the landing side, because they didn't put the money
But
where it was supposed
I'm sorry,
to
the
go.
person who is talking in the background, I appreciate that they're trying to help you, but it's making it hard for us to hear. And also, most importantly, it's making it hard for the court to make a recording because there's a certain other amount of sound in the background. So
Olivia, I know she doesn't work there anymore, but she told me that she knew that I am a self-guarantor, and like I don't know why he said that I didn't sign the lease or whatever, saying that I would be a self-guarantor, because before I got my keys, that's what I had to do.
Mr. 22, Mr.
So,
Fleeman?
Judge, no, that's why I was going to jump in. I misspoke. She moved in August of 21. I misspoke when I glanced over at the lease and I saw 22. That was the move out date was 22. The
Move out.
was 21. So I set you on the wrong path by saying
Okay, nope.
August of
That's-
21. So she is right about January 22. As I said in the beginning, if she had shown me a payment that she didn't get credit for and that we had cashed it, I would have told my client to issue her a check. That's just very simple. Or at least offset the $450.61 that she owes for the utilities and stuff. So I don't know what's going on with the $500 relative to the video proof or the other emails, whatever. Ms. Mitchell did not file a written response to my motion, so I don't have any documentary evidence that she would be speaking of. More importantly, she's not submitted any affidavit of facts setting forth that there is, in fact, a meritorious claim here. I think that under C10, plaintiff is entitled to summary disposition.
Ms. Mitchell, did you receive a bunch of documents, all of these exhibits from Mr. Fleeman?
Yes.
Okay. Do you have them in front of you?
No.
Did you review them? Did you read them?
I did not read all of it, no.
Okay. Did you submit any documents to Mr. Fleeman or to the court?
Yes, I believe I sent over my money orders, the emails, my ledger that I have, the copy of the lease that I have.
Okay. Were those sent to Mr. Fleeman?
Yes, I did it through M-File.
We haven't seen evidence provided to the court that a case can be made or sustained. So,
Can I refile?
Well, generally, we dismiss cases what we call as without prejudice, allowing people. Well, actually, no, because this would be an adjudication on the merits. To be an adjudication on the merits, meaning this matter is decided. There may be an appeal process. You probably want to speak with an attorney. Because are you seeking attorney costs and fees?
I am. I did not make a specific request for that, but for sure I have invested an enormous amount of time into this because we have been here a number of times. I would appreciate some award of attorney's fees. I don't know how the court normally wants to handle those.
I'm sorry. I'm going to rule for summary disposition.
And your Honor, costs and fees.
So what we will do is have a hearing on costs and fees at that time. Okay, so Mr. Fleeman, if you want to submit A motion with proposed costs and fees, the court will decide.
I don't know what's going on.
Okay, so Ms. Mitchell, I'm dismissing your lawsuit. What comes up next is Attorney Fleeman has asked the court to have you pay his costs and fees for the lawsuit, which is something that happens in civil suits. The court has
Are
not
you
decided.
sure?
Excuse me, please don't interrupt. So the court.
Several days later.
Good morning. And Ms. Mitchell, if we could turn on your camera. There we go. All right, thank you. All right, we are on the record in the matter of Trinethia Mitchell versus Chandler Crossings. This is case 23-02184-GC. And may I have appearances for the record, please?
Good morning, Your Honor. Tyrone Fleeman on behalf of the defendant in this matter.
Thank you. And Ms. Mitchell, if you could state your name, please.
Hi, Trinethia Mitchell.
Okay, thank you. So we are here today for a hearing on attorney costs and fees. And I have in my electronic My File a filing of the requested costs and fees that Mr. Fleeman is seeking from Ms. Mitchell for the cost of defending this lawsuit. Ms. Mitchell, did you receive a copy of these?
Yes.
Okay. So what I'm going to do then is ask Mr. Fleeman to say why he believes he should receive these. And then I'm going to ask you, Ms. Mitchell, to make your argument against why you should have to pay some or all of them. Okay?
And Your Honor, I will say that I have had some contact with Miss Mitchell through an attorney that is helping her, Tammy Musichuk, and we had some discussions, and I sent to Miss Mitchell a conditional dismissal where she would pay basically $1,050 at the rate of $50 per month starting June 1, and I sent it, but I made some typographical errors in her name, and so she advised me of that. I corrected it this morning, and I sent it to her for signature, but I haven't received it back yet. But I see that Ms. Mitchell's in her car. I don't know if she has the ability to pull that up and sign it while on a phone.
I have it. I'm gonna sign it.
Okay. Would we like to temporarily pass this?
Yeah, if you want to go ahead and put us into a breakout room real quick, and we can work on her sending that over, and I'll know as soon as she signs it, the system will send me the signed copy, and I'll know I have it, and then I can My File it with the court.
Okay, excellent. I'll have Ms. Lewis put you guys in a breakout room, and I'll be here. So.
Thank you.
A few moments later.
And I just My Filed that document, so I don't know how long it takes to actually show up on your side, but I know somebody in my office is doing that right now.
Okay, let me just, I think there are a couple steps where it gets moved through the process, but let me check.
Okay.
Okay, well, I don't see it, but I will take you at your word that you have submitted this, and believe that will then end this case. Is that an accurate statement, Mr. Fleeman?
That is correct. Yep. The conditional dismissal is just that she's going to pay $1,050, and that will be applied to her delinquent balance of $450.61, with the remainder to attorney's fees and costs at the rate of $50 per month starting. I'm sorry, I said June 1. I meant July 1.
July 1.
July 1. And that so long as she pays it at that rate, it'll just stay dismissed. If not, then a judgment could enter for the full $450.61 plus the $2,320 that I'm requesting in fees for a total of $2,770.61. Obviously, that would be minus any payments that were made between now and said default. But as long as there is no default, it'll be $1,050, period.
Okay. And Ms. Mitchell, is that an accurate statement?
Yes.
Okay. All right. Well, thank you both very much. And I wish you both the best of luck. I think that will be, at least Ms. Mitchell, happily, this is the last time she'll see me in her life, with any luck, right? I think Fleeman, you might not be so lucky because I think you've had other cases here. Yeah. So at least, Ms. Mitchell, you can also take joy in the fact that Fleeman has to deal with me again.
That's right.
May even feel a little sorry for him in some corner of your heart. Okay, thank you. That is all for this record. Again, best of luck to you both. Goodbye.
Thanks, Judge. Have a good day.